Disputes Decoded with me, Chris Campbell. This is an ARB Tech podcast series where we will take a deep dive into a variety of legal tech issues by way of candid interviews with selected subject matter experts. Technology has, and always will, have a profound impact on dispute resolution. And in this series, we'll give you insights into where we're going next. We will demystify complex concepts, decode the jargon, and provide practical insights on advancements across the legal tech space. Join us as we navigate this future where law and tech converge. Welcome to Disputes Decoded, where we download the field of arbitration into the future. All right. So last time on Disputes Decoded, we were talking about smart contracts. That's where we left off, along with talking about sort of what is a smart contract and crypto disputes and kind of what they look like. Still with me today, I've got Nino and Josh, who you recall from last time, and they were both dropping some knowledge on us about how crypto disputes work and how they interplay with the broader crypto world. Nino, I'm going to come back to you. You've talked a little bit about, I guess, how different jurisdictions address crypto disputes. I guess I'm curious to know, what is the US versus the European countries' view of DAOs as legal entities? And when you are taking a DAO to court, who do you sue?
That's an excellent question. It has cost me many, many long nights, Chris. There are two issues with DAOs. One is, as you said, who do you sue? And the other one is more legal point of view. I mean, what is the conflict of law issue? What is the private international law status of them? The first issue, who do you sue? It depends under which law you look at the DAO, because I mean it's very difficult to qualify a DAO, to determine what is the legal status of a DAO, because there are only very few jurisdictions that have any legislation on DAOs. So in most these continental legal systems, they will be qualified as a simple partnership, and usually simple partnerships they cannot be sued. They have no standing to bring suit. They have no standing to be sued. So what you need to do is you need to sue the individual members of the DAO. So usually the governance token holders. And here the big problem is you don't know who they are most often of the time. So you have this anonymity issue and you need to do your own research, hire an investigator, try to find at least a few people that do hold those tokens. Then the party can start. The international private law issue is because, I mean, it's in the name, decentralized autonomous organizations. And our private international law system relies on a closest connection test. So you want to pinpoint the organization to one specific jurisdiction. The entire point of having a DAO is to have a decentralized leadership structure. So there's these two concepts, our private international law system and a DAO, they do not match at all. And for me, to this day, it's an enigma how you want to determine jurisdiction or choice of law when being faced with a DAO. And there have been a couple of scholars writing about this, and they seem to be as puzzled as I am. So if any of our listeners are still looking for a thesis for their master or their PhD, please write about this. I would really like to find out what the solution is so I can finally have a good night's sleep again.
Hey, well, you listeners, if there are any plucky students out there, it sounds like you just got your inspiration, so go forth. I guess I think about a lot of the seeds that the both of you have planted throughout the conversation so far. And I wonder, certainly there's a number of things that probably could change, and maybe there's a lot of nuanced solutions that you might have. But suppose I were to give you the magic crypto wand. You could wave your hand and that would fix one thing or change one thing about the crypto space, in particular crypto disputes. I wonder what that thing might be. And I'm going to give you the metaphorical wand first, Josh, to sort of give us your thoughts there.
Thanks. Before I do that, is it okay if I just tack on to something that Nino was saying
You've got
about?
the wand. You can do whatever you want.
So for DAOs, I think one of the challenges also is even defining what a DAO is.
Hmm.
Because is it just a group of token holders where there had been a token generation event, right? And now they have some sort of way of working together, or in certain instances, you might actually have like a Delaware LLC, and that LLC may or may not have a Wyoming DAO wrapper, right? So there are lots of different permutations of what could be a DAO. So that's a for those writing their papers or doing their research right now. There's a lot of different angles that you potentially could take. And the question of whether, if there is the ability to opt in via private law to a particular organizational structure, whether that might ultimately be helpful for limiting liability versus having this very decentralized approach. So, in terms of my magic wand, I think what I likely would wave it for in the US is to have enhanced rules on market structure. This is something that's been working its way through the courts and through Congress. Right, we most recently have the Fit 21 Act that's been introduced, but before that, we had, and contemporaneously, we had things like the Digital Commodities Consumer Protection Act or the Lummis-Gillibrand Act, all of which have focused on finding ways to separate out in clear ways the jurisdiction that currently overlaps between the SEC and the CFTC. This is very important because, as we've seen in notable enforcement actions that are going on right now, including against various popular trading platforms for digital assets, but also in all kinds of different enforcements, the question of whether something is a security or a commodity. Right now, our law actually says, at least the CFTC's view, is that digital assets generally are commodities and they still may be securities, right? So there is, in fact, this overlap. Having some kind of clear divider and, relatedly, some kind of market structure that says, here is how you have a platform that trades, for example, both things that may be digital commodities and not securities like Bitcoin, and how you trade digital assets that may be securities. Just having a clearer division, I think, would benefit the industry greatly.
The major thing I take away from that answer, Josh, is clarity. Basically, to understand the rules of the road so that people can know where to drive and where not to.
Exactly. I mean, what I would say is some things are pretty clear, right? If you're capital raising using a token, we know at this point that the SEC is likely to believe that that is a securities transaction. There are lots of questions once you go one level further about whether it's what that means, but that's kind of where we are with a lot of different areas in the US where we know maybe what the answer is to the initial question, but we don't have a comprehensive roadmap. We have regulators who say, oh, laws exist and they do apply, and you should figure out how to apply them. But yet, we have guidance, we have proposed rules that haven't yet been introduced, that where there's been market feedback. We have other rules that have been introduced or other guidance that is being, in many cases, pushed back on, including in Congress. But we don't have a comprehensive roadmap from how you go from point A to point B to point C to point D, right? We have like point A.
And of course, as people operating in the space, it's, I mean, ideally, no one wants to go to jail and or get ranked, sanctioned, or regulated. But how do you avoid that when there's not clear rules of the road? It's kind of like trying to drive a car in the middle of the night without your headlights.
Yeah, I mean, the other thing, and I will zip it after this, but I would just say I think if my magic wand is still working for
It
one
is.
more second, what I would do is I would help educate people more, which we're trying to do, about what the potential consequences of certain actions may be. Because I think because of how vocal the SEC's been over the years, people are very, it's very front of mind whether something could invoke enforcement or could lead to the ire of the SEC. But what people don't necessarily prioritize in the same way, at least previously, now of course things are changing. And this is not for lack of seeking legal advice. It is just literally because when something is more prominent in your mind, sometimes you're not thinking of the others, is that, unless there's fraud, it's probably unlikely that you're going to jail for a securities law violation, like a Section 5 violation. But if you violate things like know your customer, anti-money laundering, like the Bank Secrecy Act stuff, and or sanctions, there's a high likelihood that you will have jail time. So getting people to focus on those sorts of things, like whom you should be excluding, what checks you should be doing, this is something that I think is very important because as Treasury and others have pointed out, decentralization doesn't matter for those things.
Nino, what would be the one thing you would change?
Think I have a much simpler wish. I wish that all the DAOs, when they enter into a contract, would use a wrapper entity, just a standard limited liability company, because then you would do away with many of the jurisdictional issues that I mentioned before. And it's also about protection of the members, because I mean, some people, they buy a governance token of some DAO and they think, now I'm part of this DAO. They're maybe on the Discord channel, they send 2-3 messages, then they forget about it. And suddenly 2 years later, they might be liable in a lawsuit because they hold this governance token. It's a horrible idea that this could happen, and it's so easy to avoid it. And I think here still some education needs to happen, but the trend that I've seen in the last 2 years is really that you see more and more DAOs using a wrapper entity when it at least comes to contracting.
Okay, well, look, you heard it here first. For you crypto ladies and bros that are out there, let's take another step forward. I realize actually we're on the back half of the conversation now and sort of close to the end of our time together. And and we'll stick with you for just a moment on this question, maybe more fundamentally. And it's not necessarily a wish or anything that you would maybe change, but what is something that you wish people more broadly knew about crypto or crypto disputes that you just wish that people had a better appreciation for?
I'm going to give some advice to the lawyers out there when they're dealing with crypto clients. One, be very critical of your client in the beginning because there's still a lot of fraudsters out there. Get money on accounts and tell them what the dress code is for an arbitration hearing. Because I'm sorry to say it, Chris, a hoodie is not a good look in a hearing room.
But it worked so well in the Social Network, the Facebook movie. I mean, or the Meta movie. I'm sorry.
Yeah, but when you're trying to sell to a tribunal that your client is not just some shaky startup, but a proper player in the crypto industry, it helps if he's wearing at least a shirt. So really discuss the dress code with your client before going to court or an arbitration. I wish I had known this 3 years ago.
Very
Sounds like there
well.
might be another rematch for this boxing match.
Hey, listen, the hoodies versus suits, track suit versus a court suit. Now that's very well. So be critical of your client, tell them the dress code,
Get
and
money on accounts.
get money on
And
it.
this is not, I mean, again, this goes also for me to the issue. Are you dealing with a credible, genuine client? And when I'm saying get money on accounts, I really mean hard, cold, old-fashioned fiat money. Because it's just, I mean, if they have trouble already sending that money, just be extra critical. Because this is simply my experience when I had issues to just get some fiat money on accounts, things generally did not go so well.
Well, I will say that I had a business school professor who called this the Snoop Dogg principle of I keep my mind on my money and my money on my mind. So take that for what it is. Josh, how would you characterize something you wish someone knew about crypto?
Well, I think more and more people are knowing this now, but I still hear from people who are not involved in the space or who are just getting involved in the space, but frequently from those who are critics of the space. This idea that digital assets, including Bitcoin, are not traceable, right? And that they're used, solely or primarily for illicit transactions. I think hopefully listeners know this, but actually Bitcoin is eminently traceable, right? And there are actual companies that even the three-letter agencies in the US and others around the world use to help them trace transactions. And so I think that is very important. Certainly there are some privacy related tools or tokens that for which it may be more difficult to trace. And as we talked about earlier with mixers and things like that, tumblers, where there may be some ways that make it more difficult, like I said, to trace. But generally speaking, it's very traceable. And I think if would be criminals were to use Bitcoin instead of fiat, my personal view is it probably would be easier to catch them. Um,
Absolutely. I think that's, well, not that I am a criminal, but I think that sounds like good advice for anyone is to be mindful that your transactions are being monitored on and can be followed. I guess as we're wrapping up here, final thoughts on these last couple of questions here. I guess I wonder, do either of you are you familiar with, have you heard of, do you have any experience with these crowd-funded dispute resolution platforms such as Claros or other such platforms?
I looked into it. It's a very interesting concept. I mean, it's basically you have jurors voting on cases, and the jurors are incentivized to vote with the majority because only that's when they get paid. I'm skeptical whether it will really take off because, as I said, they're incentivized to vote with the majority and not necessarily for the legally right outcome. And I mean, there are a lot of cases on there, but they're very simple cases with very binary options. They have proof of humanity cases and whether listing requirements are met, so whether the logo is in the right place in the application. So it's very simple. Especially Claros, they're doing a lot of marketing. They're working hard on it. I think they've just come out with a new version. So it's definitely something to be watched.
How about you, Josh?
Yeah, I don't have any knowledge that goes beyond what Nino just mentioned. But what I would say is I agree that we have to really think about incentives and sometimes the perverse incentives. I'm not saying that that is what is happening here, but just in general, if you think about a jury trial, right? If you have jurors incentivized to act in a certain way, is that really what we want? I guess in some instances. Now, in some instances, as Nino said, if it is a simple dispute or something like that, maybe that is a good way forward. And certainly, no disrespect intended to any of these platforms. And again, I haven't looked into them closely. I would just think about just at a human level, whether if we had a situation where we had 12 jurors, right, and we need unanimity, whether we want people to be able to dissent because they actually feel that way and not because, oh, if we get a unanimous verdict, we're all going to get paid. So that's what I would just say. But that's more
Maybe
of a human thing and not anything to do with those platforms.
maybe
Go ahead,
one
Nina.
thing to add, because I mean, what those platforms show is that there is an appetite within the community for alternative institutions. This might also be a bit of a wake-up call to the existing arbitration institutions, because I mean, two things that are not a perfect match for crypto disputes is the speed, because they have a completely different understanding of what fast is. Fast is not an expedited procedure that lasts 6 months. Fast is days or weeks. And two, it's the arbitrators that get appointed to those cases. You just need to make sure that they have some crypto expertise. When you're at the hearing and you realize that this 62-year-old arbitrator thinks that crypto equals Bitcoin, it just does not go down well with your client who thinks we've chosen arbitration to have a real expert. So I think these are probably two issues where the arbitral institutions really need to improve in the next 2 or 3 years.
I agree with Nino, and I actually think that that's one of the pluses about these types of potential processes or platforms is that you may have people involved who do have more knowledge, right? And so maybe this is, as Nino said, a hunger to have more knowledgeable users and builders, contributors, right, who really understand the dispute and really understand, okay, what should have been foreseeable here, or things like that, in a way that traditional, I have to say though, in the US, I've been really impressed with how the judges, how knowledgeable many of them have been. But then again, I guess it's been building over time. But certainly in some of the major, big headline cases involving digital asset platforms, some of the, if you listen in on the oral arguments and things like that, it's really thoughtful, like under the hood with a lot of questions. But I do think, and I'll wrap it up. I think it's one of the things that this goes back to what Nino was saying earlier, but about a duty of competence, right? Certainly under the rules for lawyers for professional conduct in the US, but I'm sure around the world, like you have a duty of competence. And if you're going to be practicing in this area, you need to understand what you're working with. And if you need to ask questions, you need to not worry about looking foolish in front of your client. You need to keep asking the questions until you understand.
What isn't necessarily surprising is that as there's more general knowledge of like what crypto is and how it works, that you would have like really senior and advanced jurists that once they actually understand what an apple is, what an orange is, they can apply that to the principles that they already know and understand. But before that, it's like in the way that some folks might call it all video games a Nintendo. Like, it's sort of, and if you can't distinguish between those things, it kind of just gives little efficacy to the process. It's kind of what I would imagine a lot of the clients or the users would be feeling in that way. I've got one final question for the two of you. Whoever wants to take it first is just some, I guess, aspirational, inspirational thoughts or advice that you would give to folks that are looking to make their jump into maybe not crypto specifically, but the crypto disputes world or crypto legal world.
Since it's International Women's Day today, I'm very happy to give the floor to Josh and give us some inspiration.
Aw, thanks, Nina. It's very kind of you. And I've been saying this for a long time, but I don't think it is any less true. It's a wide open field here. Some of us have been in the space for years, but at the same time, the technology is evolving. We're seeing TradFi and others come into the space, and new products and services being introduced every day, new developments unfolding, along with new enforcement action decisions or new regulations. And so I think, unlike many areas of law where the basic legal principles were decided a long time ago, and there are practitioners who've been practicing the same area of law perhaps for 40 or 50 years, right? Like what I used to do in traditional finance, like leveraged finance. Here, we need new eyes. We need new thoughts. We need, as Nino said, people to be writing their thesis about DAOs and thinking about this. So I would just say it's a place where you can really make your mark. We're still early days, and I think just as, there's a very decentralized ethos in much of digital assets generally, I think we need this incremental learning and these inputs from others to develop together with regulators and legislators and entrepreneurs what this path forward, both from a legal and regulatory perspective, but also from a technology perspective, what it's going to look like.
Great. No, I think that's a great inspirational message. How about you, Nina?
I agree it's a good space for young lawyers, especially for young disputes lawyers. Because if you think about it from a business development or building a business case perspective, it doesn't count against you that you're not yet 55 years old. Most of your prospective clients there will be young and they want to work with young people. So for me, this has been a unique opportunity to build up a client portfolio, which I do not think I would have been able to build up, for example, in traditional banking or in the commodity sector, because those sectors are just a bit more conservative. They want to have that gray-haired lawyer who really looks like a lawyer and who feels like a lawyer. And crypto is a bit different in that regard. But I mean, if you really want to get into this space, you need to do the groundwork. You need to read a couple of books, try it out yourself, go and buy a couple of tokens, open up a wallet, because otherwise it's difficult to get a feel for the issues that really matter in the end.
I'm certainly a neophyte myself. I read about it. I have written very few things about it. It's not something that I would feel good giving advice about, but I think it's really fascinating. And I think what's really been apparent in this conversation across these two sessions is it sounds like it is a little bit of the old Wild West when we talk about what's possible for the legal world, for crypto more broadly, and it's in its exciting time. Nino, Josh, that was our last substantive question. But before we get out of here today, Josh, maybe you can tell us where people can find you, find your work, and follow things that you're doing.
Sure. Thanks so much. Well, I can be found definitely at my law firm website, right? At linklaters.com. I'm also on LinkedIn and I publish frequently there, as well as post from time to time on the artist formerly known as Twitter, now known as X. But I have a podcast called Crypto Facto with Josh Clayman. And I also have a weekly informal or less formal wrap up as part of the Wall Street Blockchain Alliance called the WSBA Weekly Crypto Roundup. So I think those are some places you can find me.
Thanks for that, Josh. Nino, where can people find you, and how can they follow your work?
Well, they can also find me on my law firm's website, ndlegal.ch. I do respond to old school emails. That's probably the easiest way to contact me. And of course, I'm on LinkedIn, and there I have a newsletter on crypto disputes that you should all sign up to.
I see. A little product placement. I like it. How about you, Nino? Any shout outs or any name drops you want to give to the folks listening at home?
I'm sure shout out to Lulu, our office dog. She's been quiet during the entire recording, no barking. I'm very proud of her.
Very good girl. All right, Lulu. And Josh, how about you? Any shout outs?
I guess I would give some shout outs maybe to my kids who hopefully, as I just learned when I was having a call and one of my children was in the next room, who then started telling me about subpoenas and what they are. And I said, what are you talking about? They said, well, mom, when you Google you, a lot of other stuff comes up. So sometimes I read it. So yeah, shout out to my kids and to all kids out there, the next generation. As we're building the next iteration of the internet, we hope to see you all there. And I guess also to the crypto lawyers around the world who are contributing to make this future a reality at a foundational level.
What a sharp kid that knowing about subpoenas. I mean, yeah, that's pretty cool.
I thought I was going to hear some gibberish, truly, but but actually she was giving some pretty specific examples, and that's what prompted me to say, "Where did you learn this?" So
Yeah, no, it's interesting. And look, the shout out I'll give is to the ArbTech team for facilitating this great conversation, and especially Sophie, who is definitely someone that's been active in sort of this crypto legal world as well. And so, hats off to y'all. I think that is where we're going to run to the end of our time today, the end of our blockchain. Nino, thanks for being with us today.
Thank you so much for having me. It's been a pleasure.
Josh, thank you for being here today.
oh, my pleasure. This was really fun, guys.
I agree. And thank you both so much. And listeners, thank you for joining us for this two-part episode on crypto disputes. And we will see you in the next episode. And until next time, you've been listening to Disputes Decoded by ArbTech and Tales of the Tribunal.